So, Robert, thank you for joining me today and agreeing to answer a few questions. My first question, so as a B2B marketing leader myself, which pieces of data protection legislation are most relevant to my role?
Okay, so the Privacy and Electronic Communications Regulations 2003, known as PECR, or sometimes referred to as PECR for short, is probably on a day-to-day, as it were, basis the most relevant piece of legislation, I would say, in front of, as it were, but as well as the General Data Protection Regulation.
Okay, thank you. And how do they apply to marketing activities? So if we take, for example, sending promotional emails, digital advertising, or tracking users' activities on a website, all things that B2B marketers are very interested in doing, all things I imagine that at least have an element of consideration around data protection.
Yes, once you're talking about processing, which basically means doing something with people's personal data, which is information that basically enables someone to be an individual to be identified or make them identifiable, then you need to consider really whether data protection plays a role, or the data protection laws or rules that I've just mentioned play a part, if you like, in what you're doing. In other words, whether you need to take those into consideration when you're doing what you want to do. And the crux of this is really that you've, on the one hand, if it's personal data, it's going to be governed by the General Data Protection Regulation, the GDPR. And if that personal data is being used for marketing purposes, then perhaps, and it does depend, as well I've said, perhaps, the PECR will come into play as well.
Thank you. So, I mean, I've talked about being involved in B2B marketing, or marketing to individuals within an organisation. But of course, there are lots of companies and individuals out there who want to market to individuals, to consumers.
Yeah.
So how is that different? So how is B2B different to B2C?
Okay, now this is a really important and crucial difference at the end of the day, because whereas the GDPR will apply full stop, if you like, across the board, it just applies, remember, to personal data. And an example of personal data would be someone's email address, for example, including someone's personal or corporate email address. So, my email address, my business email address, robert.wassell@normcyber.com, that would enable me to be identified, or makes me identifiable. Therefore, it's personal data, and therefore the use of that will come within or under, if you like, the GDPR. However, in terms of marketing, there's a key difference as to whether, as you say, it's B2B or B2C. And the PECR is largely focused on the B2C market rather than the B2B area, if you like. And that's really because the way to look at it in a way is if it's a piece of almost consumer protection law, if you like, because the idea is that people are not to be caused a nuisance, if you like, by marketing activity. So, for example, if a business or an organization wants to send an email to somebody, then do they want to receive that email in the first place, if you like? And what the PECR does basically is it says if you want to send a marketing message, an email, we'll stick with the examples of emails because it does apply to beyond emails, but we'll stick to just emails for the moment, then basically you will need their prior consent in almost every situation, every set of circumstances before you can do that. In other words, you can't just send them an email if these are people who are now individuals, consumers, if you like, if you think of them in those terms. Then you can't do that unless they've already previously agreed that you can do that, if that makes sense, that they've given you their prior consent, as it were, for that to happen. Whereas for B2B, that doesn't apply. The PECR doesn't cover that situation. So you can send a marketing message to a corporate, a business email address, even if you do not have that individual's consent in the first place, that person's consent, that recipient's consent.
This might sound like a silly question. What does consent mean? It kind of means granting permission. But I suspect it's a little bit more intricate than that in terms of the mechanisms that you use to gain consent, and perhaps whether individuals actually recognise that they're giving consent.
Yes.
And maybe even allowing them to withdraw that consent.
Yeah, no, these are really good points, because the GDPR is very, very focused, if you like, on consent and what consent means. In other words, what is valid consent? Because if you don't have valid consent, then obviously you may have consent, but it will be invalid, and therefore it will not work, if you like. It will not be legal, if you like, and therefore you may as well not have any consent in the first place, if you see what I mean. And what the GDPR says basically is that consent must be a positive action. So, for example, what you can't have anymore under the GDPR is a pre-ticked box. For example, before the GDPR came in, it was quite common to see pre-ticked boxes on forms and so on and so forth. And therefore, the person concerned didn't have to do anything, if you see what I mean, other than possibly untick the box. Now, that's all gone. That's all. You can't use pre-ticked boxes anymore, but you can use unticked boxes. In other words, you can obtain consent, valid consent, by asking someone to tick a box. Because by ticking the box, not only obviously are they, as it were, indicating their consent, but they're doing something. They're taking an action by ticking the box, and that is a positive action. They're saying, yes, I am giving you my consent to whatever it is. But at the same time, you must be clear what it is. They must be clear, if you like, because you've made it clear to them what they're giving their consent for. So in other words, simply saying tick this box won't be good enough. You must say, in effect, tick this box if you want to, complete that sentence, as it were, if you want to receive our newsletter, for example. And even then, depending on what you intend to send them, for example, if you're producing more than one newsletter, some organizations have more than one newsletter, for example. So if that is the case, then you will need to have a separate tick box for each newsletter. You can't ask someone to tick a box for a newsletter, but in fact that means they're going to get 6 different newsletters from you, if you see what I mean. So you need to give quite a lot of thought into how you get consent, and the most obvious and the easiest, and I would say the standard way to get consent nowadays, is to ask someone to tick a box. But accompanying that, it must be very clear what they're giving their consent to. In other words, what will happen if they choose to tick that box. And I say choose, by the way, let me just say that while I remember, it is their choice. So you can't present something that effectively takes that choice away from them. In other words, you can't effectively almost make them tick that box, if you see what I mean. In other words, if they don't tick that box, then something else won't happen.
Yeah, and I have seen that on occasion, myself as a consumer, that if I wasn't willing to tick a box, then whatever other offer it was that I felt I wanted would basically be withdrawn.
Yes.
For example, because I couldn't submit my details without ticking the box.
Yes, that's a good example. And that's not allowed, because then that's not genuine consent, if you see what I mean. I mean, the consent has to be to receive the marketing message. So if someone wants to, download a white paper, for example, if you're offering people to do that, then that's fine. But if you're asking them to tick a box to download it, and as a result of ticking that box, they're going to be sent a marketing message, a newsletter or whatever, then you must make that clear to them, and you must give them that choice. In other words, they must be able to download the white paper if that's what you want them to do, without making it a condition that they must also receive a newsletter or whatever it is from you.
Yeah, no, I understand. And I mean, I think, the issue of kind of withdrawing consent, obviously we, again, using the example of email, it should be relatively easy for people to unsubscribe. Most marketing automation and kind of nurturing systems that we use nowadays have that and have that built in as well. And presumably that's something that the GDPR is concerned with, because, just like any other choice, people have the option to change their mind.
Absolutely. Absolutely. And whenever you give consent, you must always be able to, as you say, change your mind, withdraw your consent. And you can't You can't stop that happening. You can't ask someone to tick a box, for example, going back that, and say to them, even if you make it ultra clear, by ticking this box, you are irretrievably giving your consent, or words to that effect. You can't do that. So whenever someone, and it's the law, if you like, whenever someone gives their consent, they have the right to withdraw that consent. And you have an obligation to make it easy for them to exercise that right, because that's the way the law looks at it. They have a right to withdraw their consent, and you must make it easy for them to do so. And in the context that we're talking about, that would be, as I think you've already said, an unsubscribe option. So you send them an email, and every single email makes it clear that if they wish to receive no more emails, as it were, that they can unsubscribe, and you make it easy for them to unsubscribe. Not a difficult procedure, for example. What you can't do is, which again I still see sometimes, is, if you wish to unsubscribe, then go here. In other words, you go somewhere else. You can't unsubscribe exactly at that point, and you go somewhere else, and it's quite a palaver, as it were, about being able to do it. None of that is going to be anymore, as it were, legal. It all has to be very easy, very straightforward. You can't effectively stop people from changing their mind.
I mean, I think one of the other things that I hear quite a lot in conversations with other marketeers, and indeed people who have in other roles as well, is around this whole concept of legitimate interest.
Okay.
A lot of companies rely on legitimate interest. And I don't know, it kind of always, in my head, I always think, is it you that have the legitimate interest in your potential customer, which I'm sure you do, or is it their interest in you? So what's legitimate interest all about, and how does it apply in this situation?
Okay, so legitimate interest is a lawful ground for processing personal data. It's one of the 6 lawful grounds out there, and it is the most vague ground, if you like. And I don't say that critically. I just say it as a fact, as it were. And it's right to say that organizations can rely on legitimate interest as a lawful basis for processing personal data in quite a wide variety of circumstances, including arguably marketing. But where I think a lot of organizations go wrong about this is that where they need to obtain consent, which we've been talking about, for example, then the way to look at it, if you like, the easiest way, and perhaps me to put it, is where you do need consent, that trumps legitimate interests, all right? So you can't, it's not a choice. You can't say we're choosing to rely on legitimate interests and we're not choosing to rely on consent. If the PECR, if the law says you must get someone's consent, then end of story, you must get someone's consent. And you can't, there's no way around that, as it were. And where that applies, that will override any legitimate interests. So, for example, you can rely on legitimate interests to, say, collect someone's contact details, someone's email address, perhaps, we say, from, it doesn't really matter where, but from various sources, including, in the public domain. And you can, yes, I say you can use legitimate interest or rely on legitimate interest to do that. But if you actually want to market to those people, if you want to send a marketing message to those people, you can't do so. And those people are individuals, they're consumers, as we've discussed. Then you can't do that without having their consent. Does that make sense?
Yeah. No, it does. I mean, that brings me on to the next point as well. So, I was going to ask, to be honest, it is quite a complicated area, particularly for people like me. We're not data protection experts. What happens if you do get it wrong? What happens if you don't adhere by?
Okay. Well, as I say, you can have the ICO, the Information Commissioner's Office, who is the regulator in the UK, after you, shall we say. Now, the the ICO is pretty hot on this, to be honest. Of the number of prosecutions last year in 2020, I think I'm right in saying that over half were for this sort of thing we're talking about, against companies conducting marketing activities for failing to comply with the rules, and largely what that boiled down to, contacting people when they don't want to be contacted, when they didn't have consent, and when it was a nuisance to them. In most of those cases, not all of them, the ICO has acted as a result of a complaint. Not necessarily lots of complaints. In fact, in most of these cases, we're talking about low numbers of complaints. And by the way, just to clarify things, it doesn't have to be a complaint in the first place, but that's usually what triggers the ICO getting involved, shall we say. In one case, actually more recently, there were over 10,000 people complained to the ICO, but that, I have to say, is extremely unusual. But people can sue you, as it were, if they choose to do so, in any event, with or without an ICO enforcement action. And that's increasingly common these days as well. And it is and it isn't complicated, if you like. Yes, the rules are not, if you like, intuitive, and they're not instinctive, and they're not straightforward. And I think that anyone who is undertaking marketing activities should make sure that they either understand those rules or get advice to make sure as they understand those rules. Yes, but also if you take that sort of very simplistic view of, are we a B2B business? Because, as I say, the rules are largely, in terms of the consent, are aimed at the B2C. So if you're a B2B business, by and large, you can't ignore all that we talk about, because you'd still be covered by the GDPR, but you don't need the consent, as it were, to send a marketing message. But if you're a B2C business, you almost certainly will need that consent. And so, give some thought to, does this person want to hear from us? And I accept that from a marketing point of view, there's a desire to send that message, to send that email. I get that. I understand that. And there's nothing instinctively wrong. There's nothing inherently, wrong with that. But I don't believe that many businesses would want to knowingly cause people to be annoyed by those emails.
For my part, Robert, I'm certainly very pleased that I have you as our DPO, because of course I can come to you with any of these questions. And I think, what advice would you give to either B2B and B2C marketers who are perhaps struggling with kind of navigating this landscape? Because I guess that's where it's kind of crucial to have someone like you who knows what they're talking about on hand to help.
Yeah, I mean, I wouldn't say this wouldn't be, but I think it is pretty crucial, because for all the reasons that you've just said, this is your business, if you like. This is your business reputation that's on the line here. And although I can see this, that there's a tendency possibly to say, well, what's the harm of sending out a few emails? I think that you can't underestimate, and I'm going beyond what the law says now. I think you're absolutely right. This is broader. The approach there should be broader than what are the rules, what are the legal rules they are. This is all about reputation, preserving reputation at the end of the day, as it were, because, as we know, people are readily able to vent their spleen, as it were, about organizations through social media, for example, and they will, and they do. There's no doubt about that. And that's beyond the enforcement arena now. So you don't want that to happen. That is pointless. It is completely, as far as I'm concerned, pointless sending marketing emails to people who do not want to receive them, as it were. And I accept it may not always be, shall we say, crystal clear whether they do want to receive them, although that comes back to consent, of course, because that it does make it crystal clear. Without that consent, then you're taking a risk of all those areas we've touched on. At the end of the day, obviously, if you should always unsubscribe, as we've said, because if you don't give people that option, because I often get this, it'll say, well, they can always unsubscribe. Yeah, they can, as long as you put that in there, obviously, and as we said earlier, to make that easier. And also, though, don't forget, I think that's the legal way of looking at it. But at the end of the day, people don't do that. They get an email, they see it pop up, and they go, oh, not another one of those. And they'll delete, they won't unsubscribe. They'll simply delete straight away. Yeah. Therefore, as far as you're concerned, they haven't unsubscribed. They must want to hear from us. Well, that's not always the case, is it? And if you keep on sending those emails, you're just going to keep on annoying people more and more and more, arguably. And I think you should take all that sort of thing into consideration, as it were, when you're undertaking your marketing activities. And I think that far too many businesses don't have the right approach, if you like. Their approach is, we're here to market our business, and that's end of story. We're going to market our business to anyone we can find, anyone whose email address we've got, regardless, if you like, of possibly the rules, and certainly regardless of whether they want to hear from us or not. I think that's a recipe for disaster for all the reasons we've touched on. It's a waste of time and money, as well as a breach of the rules, breaching the law.
Mm-hmm. Okay. Sound words indeed. And my final question. So, just in case you missed it, Brexit recently. And there have been some rumblings from the UK government that in relation to data protection law, we may decide, we being the UK, to follow our own path, so to speak, to have a bit of a departure from what's happening in the rest of the EU. Is there anything you think that we should be aware of that's in the pipeline, or that may happen, or is it something of a kind of watching brief in terms of what may manifest from that?
Well, that is interesting, because certainly the UK government has made it pretty clear, in my view, that now it's out, now that we're out, and now the UK is out of Europe, as it were, then it's going to go its own way, to at least to some extent, in terms of data protection. But I think that most interestingly, in the context of what we're talking about of marketing here, the changes are not so much going to come from the UK, I think, but from the EU, to be honest.
Okay.
And the reason I say that is that the EU, and this is something that's been going on for years, to be honest, even before the GDPR came into effect. But the EU has been planning to introduce new marketing rules. The rules we've been talking about, they're going to change. Now, earlier in 2021, the EU finally, finally got its act together and agreed all this. That's not quite true.
You surprised me.
I know. It's still slightly up in the air, but a lot of progress has been made after all these years. And so it is very likely, but not 100% sure, 100% definite, that in 2023, in a couple of years' time, thereabouts, the EU will introduce new marketing rules, all the things we've been talking about. I'm not saying they're going to be completely different, but I think that they will be different, by which I largely mean they will be more stringent, shall we say. They will tighten the rules, if that's a way of putting it. So in other words, from a marketeer's point of view, there will be the rules we've already discussed, and perhaps some more rules to talk about, and it will make, in a general sense, marketing more difficult. Not impossible, but more difficult. So what we're likely to end up with in a fairly short time, say in a couple of years' time, is that the EU will have different rules from the UK. And if you thought those rules we're talking about now may be a bit harsh, I don't know, then you might find in a couple of years' time the rules we've got here are a lot easier going than the rules we've got in Europe. And of course, if you've got a business if you've got an organization that's doing business in Europe, you will have to play by both those sets of rules, as it were, the UK rules and the EU rules. So at the moment, the rules that we're talking about are more or less identical throughout the UK and the EU. And as I've said, they will change. So unless we also sort of choose to almost mirror image them, we will have two sets of rules in the fairly near future. So that's something every marketeer should certainly be aware of and start preparing for.
Okay, well, when we know more about that, we can come back and continue this conversation.
Absolutely.
Then. But for now, thank you very much, Robert.
Okay, thank you for asking me.